Greetings to you all. My name is CHIRATIDZO and I'm the first presenter for Group 21. The focus of our presentation is the ABCs of insolvency law. We are going to identify the international standards, but we are going to focus more on the domestic framework. I'm going to take you through the first segment of the presentation. Its purpose is to define insolvency, trace the origins of insolvency, as well as briefly discuss on sequestration and attachment of property. Insolvency is a situation whereby a debtor cannot pay back the debts that they owe. Insolvency law then provides mechanisms that ensure the equitable treatment of all creditors. In Zimbabwe, insolvency law is regulated by the Insolvency Act of 2018. An insolvent is a person who accrued more liabilities than what his assets can pay for, according to Maja and business law. In terms of the Insolvency Act of 2018, insolvent means a debtor whose estate is under liquidation. In the case of Metallion Gold Zimbabwe, Private Limited and others, versus Shatira Investments Private Limited and others, it was held that a company is regarded as technically insolvent, as thus financially distressed, if the liabilities of the company exceed the assets. According to Trustee in business law in Zimbabwe, the system of insolvency law is that a debtor who cannot pay his debts may be ordered by the High Court, either on his own application or that of a creditor, to hand over his property to a trustee for a sale or distribution among his property. Insolvency law developed as a special collective debt enforcement procedure in order to provide for a fairer distribution of the proceeds of a debtor's property in among the creditors where the debtor does not have sufficient assets to settle the debts in full. In other words, where his or her estate is insolvent. Scott in the civil law affirms that the origins of insolvency date back to when young Rome was a young debtor who was unable to pay back his debts and would surrender himself to his creditor, hoping for slavery rather than death. The earliest Roman laws dealing with debtors permitted a debtor to only pledge his own body as a security by contract, and if he defaulted, the creditor could seize him and treat him as he thought fit, including imprisoning, beating, or starving him. As times have changed, a debtor retains his personal freedom but hands over his property in accordance to the Insolvency Act. Similar to Zimbabwe, whose insolvency law is regulated by the Insolvency Act of 2018, South Africa's insolvency law is regulated by the Insolvency Act 24 of 1936. It can also be noted that the Insolvency Act of 2018 consolidates the natural and juristic person regulation by repealing Chapter 604, which previously regulated the natural person debt release system in Zimbabwe through the liquidation procedure. The reform of Zimbabwe's debt release system can be traced in the South African sequestration and attachment of property. A debtor's estate can be sequestrated by way of voluntary surrender of his or her estate, while it is also possible for a creditor or creditors to sequestrate a debtor's estate by way of compulsory sequestration. A debtor who wishes to escape the pressing demands of his creditors may voluntarily surrender his estate as insolvent. This is expressed in the Latin term cessio bonorum. Section 9, subsection 1 of the Insolvency Act of 2018 provides for sequestration. It states that a debtor other than a natural person, partnership, or company that is an external or foreign company in terms of the Companies Act, Chapter 2431, which is unable to pay its debts or whose liabilities exceed its assets, may be liquidated as a voluntary liquidation by creditors if the debtor has passed a liquidation resolution resolving that the debtor be liquidated voluntarily as a voluntary liquidation by creditors.
My name is TANATSWA JENA, and I'll be taking you through voluntary surrender. Voluntary surrender is a process whereby a natural person makes an application to put him or herself under an order for sequestration. Maja in business law states that it only occurs when a debtor or his agent surrenders his or her estate by means of a petition to the Master of High Court. There are several elements that constitute a valid application, most of which are stated in the Insolvency Act of 2018. Some of these elements include the full name of the debtor, the date of birth of the debtor, any other names the debtor may have traded, whether the debtor is actually insolvent, where his liabilities exceed his total assets through the provision of a statement of affairs. In the case of Ex parte Cloet 2013, it was stated that although Section 4 of the Act requires a certain measure of notice to creditors, an application for voluntary surrender of an estate is in essence an ex parte application, and that being so, an application in these applications should make full and frank disclosure of the utmost good faith where it is required, meaning that the statement of affairs should show as is A debtor who then decides to voluntarily surrender his estate will then have to provide an affidavit which explains to why he or she avails to be insolvent. This is to be drafted by legal persons and posted to the High Court. On the first court date, if the order is granted, it is to be regarded as a provisional order, where the matter is to be postponed to a final date where the final order will then be granted. That is only if none of the creditors make an opposing application. That is if none of the creditors decide to make an opposing application to oppose the affidavit. An order may only be granted in terms of Section 14 or Section 15 of the Insolvency Act 2018, where A, the debtor is unable to pay his debts, or if the liquidation of the estate will be of advantage to his creditors.
My name is LAVENDAH MATADI and I'll be presenting on compulsory sequestration. MAJA states that compulsory sequestration occurs when a creditor petitions the High Court to sequestrate the debtor's estate, owing to either non-payment of debts or that the debtor's estate is insolvent. Compulsory sequestration results when a creditor can prove that the liquidity or realistic valuation of a natural person's estate is less than his immediate indebtedness, or where a person has committed a so-called act of insolvency. According to Nigel Commercial Law, 5th edition, the purpose of compulsory sequestration is to pay at least a dividend of the debt to all creditors, rather than fully satisfying the claims of a few creditors. The main purpose is therefore to ensure the orderly distribution of the debtor's assets when the debtor's assets are not sufficient to fully satisfy all the claims of the creditors. The requirements for granting compulsory sequestration are as follows. The creditor who brings the application must have established a claim against the debtor. The requirements for granting compulsory sequestration are as follows. The creditor who brings the application must have established a claim against the debtor. This is to mean the debtor must indeed owe the creditor money. The creditor must convince the court that sequestration is favorable to the creditor. The creditor bears the burden of proof that the seizure of the debtor's property is in favor of the debtor's creditors. The debtor must have committed an act of insolvency. These requirements are also stated in the case of Saul versus Kazi, HC 6559 of 2005. To note is that a debtor can oppose an application for compulsory sequestration on the basis that he or she is not insolvent or other valid reasons. Thank you.
Okay. My name is MUTSA CHIMINA and I'll be taking you through the effects of sequestration. Effect number 1. The insolvent is deprived of ownership of all his property, which vests in the trustee or the liquidator. Section 23 of the Insolvency Act provides that unless the contrary is proven, any property that a debtor has acquired possession of and the liquidator of the estate claims for the benefit of the insolvent state must be regarded as belonging to the insolvent state. In the local case of Saul versus Kazi of 2005, and a trustee was appointed to oversee the property of the creditor. Effect number 2. The debtor is prevented from acquiring ownership of property. Until a liquidator is appointed, all the debtor's property must be regarded as being in the custody and under control of the master of the High Court. Effect number 3. The creditor is disqualified from having positions of trust in a given company. These include that the creditor cannot be a company director. The contractual capacity concerning the liquidated estate is affected. The insolvent must obtain the trustee's approval of the contracts that have an impact on the estate property which is being liquidated. Effect number 5. All contracts involving the estate can be potentially terminated. However, the trustee can choose to terminate or abide by them. And the last effect, the creditor becomes debt-free as in the aftermath of sequestration.
Hello, my name is NDADIWA CHIHERA. and I shall be dealing with the procedures leading up to the second meeting of the creditors and also the first meeting of the creditors. To address this, I first have to deal with the matter of the appointment of the liquidator and then go into the procedures of the second meeting and finally the first meeting of the creditors. Now, dealing with the issue of the liquidator. Now, when it comes to the appointment of the liquidator, the Master of the High Court is the one who must appoint the liquidator, and this should be done before the meeting of the creditors. The liquidator is to be appointed within 48 hours of the first liquidation order. For one to be appointed as a liquidator, one must qualify as a registered insolvency practitioner under the Estate Administration Act of Zimbabwe. Now, on to the duties of these liquidators. Right. The liquidator, after appointment, must serve the debtor with a copy of the first liquidation order. This is in accordance with Section 42 of the Insolvency Act of Zimbabwe as of 2018. The liquidator is supposed to compile a full inventory of all immovable assets belonging to the debtor. The liquidator is to be appointed within 48 hours of the first liquidation order. For one to be appointed as a liquidator, one must qualify as a registered insolvency practitioner under the Estate Administration Act of Zimbabwe. Now, on to the duties of these liquidators. Right. The liquidator, after appointment, must serve the debtor with a copy of the first liquidation order. This is in accordance with Section 42 of the Insolvency Act of Zimbabwe as of 2018. The liquidator is supposed to compile a full inventory of all immovable assets belonging to the debtor and compile a list of all the records related to the debtor's affairs. Within 14 days before the meeting of the creditors, the liquidator is supposed to send a notice to all creditors whose names and addresses he or she has access to. This is also in line with the Insolvency Act of Zimbabwe. Now, moving on to the first meeting of the creditors. After consultation with the Master of the High Court, the liquidator is to convene the first meeting of the creditors. This meeting is to be held within 60 days from the date of appointment of the liquidator. In the South African case of Industrial Development Corporation of South Africa versus the Master of the High Court, Johannesburg, this is a 2007 case, the court held that deciding the date of a meeting and the date of publication of the notices in the Gazette is part of the duties of the Master of the High Court. Now, this is quite different from the case of Zimbabwe, whereby these duties are conducted by the liquidator and not the Master of the High Court. Now, subject to the meeting of the liquidators, the procedure is as follows. In the case of Zimbabwe, that is. Now, the objective of the meeting, firstly, is for the creditors to prove their claims. Secondly, for the examination of any person in relation to the Insolvency Act of Zimbabwe. Thirdly, for consideration of the report which will be submitted by the liquidator. Fourthly, for the nomination and appointment of any one person or any one or more person to be given the duty of being co-liquidators to the insolvent estate. In this matter, I've chosen to relate to South Africa. Now, in the case of South Africa, the meeting of the creditors is provided under Section 40, subsection 1 of the Insolvency Act, and the reason for the meetings are quite similar to those applied in the Act of Zimbabwe, whereby one of the reasons involves the proof of claims. Now, lastly, is on the issue of proofing. No oral evidence can be used to support a claim in the case of an insolvent estate. This is provided under Section 66, subsection 6 of the Insolvency Act of Zimbabwe. A creditor who fails to make their claim before the set date is not entitled to any share in the distribution of assets. This is also in accordance with the Act. However, according to Section 68, subsection 2, a creditor who manages to provide the Master of the High Court with a reasonable excuse will be allowed to put forward his or her claim.
My name is Tashinga, and I'm going to be presenting on impeachable transactions or dispositions. The word impeach, according to the dictionary, is defined to mean to question the validity of something. There are powers or rights given to the trustees and creditors to set aside certain transactions carried out by the insolvent prior to sequestration. The Insolvency Act provides for the protection of interests
of creditors in circumstances where the insolvent entered into a transaction before the insolvency. They are known as dispositions if included in the disposal of estates, assets, and money. In Fernhouse versus Abraham, 1956, South African law reports, the court acted by setting aside of a transaction aimed at defrauding creditors. Creditors have the legal right to impeach the validity of a disposition. The court may respond by setting aside the transactions. If the court ever decides to do so, the disposition is as a result retrospectively invalid, and the property or its value is retrieved and redistributed among the creditors. There are four main types of dispositions. The first type is called disposition without value. It is the transfer of insolvent rights over a non-value making assets, such as gifts or donations. The second type of disposition is voidable preference. This refers to any disposition of property made by the insolvent less than 6 months before sequestration, which has the effect of selection of creditors over the other. The third type of disposition is undue reference, which is made by insolvent at any time of the liability exceeding the assets. The last type of disposition is conclusive dealings. The fourth and last type of disposition is called the collusive dealings. They are applicable to a debtor who disposes of assets in a manner which eventually, in its eventual outcome, it disadvantages one of the creditor over the other. Thank you.
I am Patience Makokotela, and I'll be taking you through the second meeting, or the meeting of creditors and proof of claims meeting. So after the first meeting of the creditors and the appointment of a trustee, the master must appoint a second meeting of creditors. The trustee must convene the second meeting of creditors by notice in the Government Gazette and in newspapers circulated in the district in which the insolvent resides or his or her principal place of a business is situated. Then we move on to the purpose of the second meeting. Firstly, it's for the creditors to prove claims against the estate. Also for the purpose of receiving the report of the trustee on the affairs and condition of the estate. And lastly, giving the trustee date. The trustee must at least 14 days before the date give notice in the Government Gazette for holding the meeting and send by registered post to each creditor who is known to him or her a copy of the report together with any recommendation in respect of any resolution or direction in his or her opinion or to be passed or given at such meeting. At least 24 hours before the time advertised for the commencement of the meeting, he or she must submit to the officer who is to preside at that meeting an affidavit setting out the names of the creditors to whom copies of the report have been sent and particulars of the direction recommended by him or her to such creditors. Not only to give the fullest information to the creditors, but to enable them to give instruction to the trustee. Creditors may vote on any matter concerning the administration of the estate, but not on matters concerning its distribution. Not only to give the fullest information to the creditors, but to enable them to give instruction to the trustee. Creditors may vote on any matter concerning the administration of the estate, but not on matters concerning its distribution. The insolvent should attend either the first or the second meeting or both meetings, failure of which attracts a criminal offense. The trustee must give a report of all the transactions carried out. The report should include all matters relevant to sequestration, the assets and liabilities, the cause of the debtor's insolvency, the books relating to the debtor's affairs, whether the insolvent appears to have contravened the Act or has committed any other offence, whether he has made a subsistence allowance to the insolvent under Section 93 and Y, whether he had carried on the insolvent's business with a list of purchases and the trading results, whether any legal proceedings were suspended by the sequestration and are pending or threatened, whether the contract to buy immovable property or lease was affected by sequestration and what action he has taken. Any matter in regard to the administration or realization of the estate requiring the directions of the creditors. If no directions have been given by the creditors, the recommendation given by the trustee are deemed to be given if the master so approves. The master may give further instruction to the trustee concerning the matters in the report.
My name is Kimberley. I'll be looking at the procedure to be followed after the second meeting. So after the second meeting, the liquidator has so many duties to perform. According to Christie, these include carrying on with the insolvent business until he can sell it, assisting in prosecution of the insolvent, bringing or defending legal proceedings and attending meetings. Now looking at composition. School 10 defines a composition as an agreement between the bankrupt and his creditors. An offer of composition should be submitted to the trustee by the insolvent. This prevents the normal sale of all the insolvent assets and distribution of the proceeds among creditors. An offer of composition comes in different form. The first one being a scheme whereby the insolvent is allowed to continue his business under the supervision of the trustee and a committee of creditors in exchange for regular monthly payments to be paid to the trustee for distribution. Another form is cash payment to the creditor in return of all the insolvent assets. So the cash payment can be provided by the insolvent friends and relatives. Upon receiving the offer of composition from the insolvency, the liquidator is required to consider whether there is a reasonable possibility that the creditors will accept it. If he doubts, he informs the insolvency, who then appeal to the master. But if he doesn't doubt, he must prepare a report on the offer and send the report plus the offer to all creditors, together with at least 14-day notice of a meeting to consider the offer. The notice of the meeting should be published in the Government Gazette as provided for in the Section 120, subsection 3 of the Insolvency Act. Acceptance of the offer by the creditors must be expressed by a resolution supported by the votes of 2/3 of all approved creditors as provided on Section 120, subsection 6 of the Insolvency Act. When accepted, the composition is binding on the insolvency and all creditors. There is the case of Leak versus Bagnos, which provides that once the offer of composition was accepted by creditors, the plaintiff, by statutory enactment, became a party to the offer. The trustee's duty after the second meeting is to proceed with the selling of the estate property and the distribution of the proceeds. In Catrao versus Catrao and others, the court held that it is the trustee's duty to liquidate the insolvent estate. The trustee must sell all the property except the insolvent clothes, furniture, tools, bedding, and all essential stuff. The method of sale must be directed by creditors who may favor a private sale of assets, a sale by tender by others, or by auction. In the absence of directions from the creditor, the liquidator may be guided by the master. Thank you.
My name is Charlene Mandikis and I'm going to be discussing about trustee account and rehabilitation. I'll start by defining what is meant by a trustee account. A trustee account is a legal arrangement in which a grantor allows a third party, in this case which is the trustee, to manage assets on behalf of the beneficiaries of the trust. A trust can provide legal protection for the assets and make sure those assets are. Trust account must be produced after 6 months of appointment. This is subject to Section 118 of the Insolvency Act of 2018, which states that a trustee shall, within the period of 6 months immediately following the date of appointment, produce a trustee account. Then moving on to the types of accounts that may be included. The first one is a liquidation account. This is an account that keeps records of all the receipts that the trustee has recorded. This is subject to Section 121 of the Insolvency Act of 2018, which states that a liquidation account shall contain an accurate record of all the money received by the trustee otherwise than in the course of the business, which is the trustee, which the trustee carried on behalf of the insolvent estate. And then moving on to the second account, which is the trading account. This is an account which is used to show all the opening and closing stock, daily totals of receipts and payments of a trading account. Subject to Section 122 of the Insolvency Act, a trading account shall contain the following information and no other information. A record of the value of stock on hand of the business on the date of sequestration. B, a record of estimated value of the stock on hand of the business on the date up to which the account was made up. C, the daily totals of receipts and payments in connection with the business. Moving on to rehabilitation. This is the process whereby an insolvent applies to return to normal. This enables the insolvent to make a new beginning and discharge him from all the disabilities that flowed from all the sequestration of his estate's debts that arose before sequestration. The application to High Court for rehabilitation may be made under 5 circumstances. The 5 circumstances is that if the insolvent has obtained a certificate from the master and his creditors have accepted the composition. This is subject to Section 141 of the Insolvency Act of 2018. The second circumstance is if 12 months have elapsed since the confirmation of the trustee's first account or 2 years from the financial sequestration order. The second circumstance is that if 12 months have elapsed since the confirmation of the trustee or 2 years from the final sequestration order. This is subject to Section 141 subsection 2 of the Insolvency Act of 2018. Then the third circumstance is that if the insolvent has been sequestrated on the previous occasion and 3 years have elapsed from the confirmation of the trustee's account, unless the insolvent has been convicted of a fraudulent act in relation with the existing or previous insolvency. This is subject to Section 141 subsection 2. And then moving on to the third circumstance, if the insolvent has been convicted of a fraudulent act in relation to his or any previous insolvency and 5 years have elapsed from the date of conviction, this is also subject to 141 subsection 2 of the Insolvency Act. Lastly, provided that no application has been made in terms of subsection 4 unless the insolvent consent is given in gazette and to the trustee or at least 3 weeks notice of his intention to make an application. A partnership cannot be rehabilitated by individual partners. This is subject to Section 145 of the Insolvency Act of 2018, which states that the effect of a rehabilitation order is to put an end to a sequestration, to discharge all the insolvent's pre-sequestration debts which did not arise from any fraudulent act on his part, and to relieve the insolvent of any disability. Rehabilitation does not affect rights and duties relating to composition or to property not yet distributed, nor the liability or any liability to pay a penalty or suffer punishment under Section 146 of the Insolvency Act of 2018. Subject to Section 146 of the Insolvency Act, which states that subject to subsection 2 and subject to such conditions as the High Court may have imposed in granting a rehabilitation. Rehabilitation in an insolvent shall have the effect to A, putting an end to sequestration and discharging all the debts of an insolvent which were due or the cause in which it arisen before the sequestration. This is the end.
I'm TAGOVERWA MANDIZVIDZA, and I'm going to be talking about assignment for the benefit of creditors. Assignment for the benefit of creditors is a voluntary alternative to formal bankruptcy proceedings that transfers all of the assets from a debtor to a trust for liquidating and distributing its assets. selling of assets is done by a third-party fiduciary known as the assignee. Assignments are creations of state law, unlike bankruptcy, which is governed by a uniform federal code. The assignee develops a budget and plan for the assignment for the benefit of creditors. He also takes inventory of the assets of the business, liquidates the assets, gives proceeds to the creditors, and winds down the business. It takes a year to complete the whole process of assigning benefit for creditors. The assignee invites vendors and customers to bring forward their claims during the year it takes. It is cheaper and faster than declaring bankruptcy. It also provides greater return to creditors. Dissolving or transferring a company through an assignment of benefit for creditors often avoids the negative publicity that bankruptcy generates.